If I turn it on,
And then go to maybe main jail.
and I'll go to the main jail.
Yeah, there you go. So that no signal is probably in the context still.
It is. That's what I was going to tell everybody. I just got a call from Bill, I think it's Patowski, and the Conte facility is 2 out. They're heading over there to fix it, and he's going to come and let me know when it is available. But if we come to somebody in the Conte facility, we'll just put it to the side, okay? All right, and is everybody ready?
We're ready here at Main Judge.
Okay, so is that Mr. Romero? Yes, sir. Good morning. How are you?
Good morning, Judge.
Mr. Romero,
I'm
on the
doing
way
well.
in today, I was thinking, what time do you get there in the morning?
Here I usually get here probably around check-in 7:50.
Okay, well, I was thinking of all the people you have to talk to. I can't imagine how long that takes. And you do a great job. I appreciate it.
Thank you very much, Judge. Appreciate it.
Okay, so let's go to Janelle Dianteri. Is he at the main? She's at the main. Okay. Ma'am, I am sorry. I'm butchering your name. I'm sure, but you are being held on an aggravated assault with a deadly weapon. They're alleging it involves domestic violence. I have read the probable cause affidavit, and I have find probable cause. And we're here to set your bond, and I'll hear from Mr. Romero first. Mr. Romero, we can't hear you for some reason.
The microphone was on.
Now I can hear you.
Okay, I'm sorry about that. Let's see. And speaking with Janelle, she's been residing in our community since she was 10 years old. She is 29 years old at this time. She's a stay-at-home mother. She has 3 children, Judge, ages 12, 10, and 7. At this time, since finances are tough for her and her husband, she's actually planning on starting to work, so she's actually looking for employment. She's also planning on attending Miami-Dade College. Financially, though, she has no money in the bank, no property. Her husband right now is the only provider for the family. He's a taxi cab driver making approximately $300 a week. They live in Hollywood. My understanding, the alleged victim are siblings. They live in Miramar, so she lives separate and apart from the alleged victims, Your Honor.
Okay, Mr. Romero, let me hear from the state.
Okay.
Okay, now this is an aggravated assault with a deadly weapon. Is that a dangerous crime?
Yes, it is, Judge.
Okay, Mr. Romero, do you have any contention regarding it's under the dangerous crime statute?
It is an aggravated assault, Judge. From my understanding, if the state can confirm, I didn't hear what the state said. I think their microphone was off. This is Ms. Janelle's first exposure to the criminal justice system. Considering her strong ties to the community,
No,
I would ask you...
Mr. Romero, I don't mean to interrupt you. I must set a monetary bond, though. Am I correct?
Correct. What I'm asking for, Judge, is for you to consider a $1,500 bond.
Okay, what I'm going to do is set a $1,000 bond with pretrial release, standard pretrial release. She is to report in twice a week by phone and once a month in person. She is to have no contact in any form or manner with the alleged victim in this case until further order of the court. Ma'am, do you have any questions?
No.
Okay, thank you.
Okay, when you get released today, go ahead and go to this place, okay?
Okay, thank you.
For the perfections of probation in Florida.
Andre Drusis?
Mr. Drusis is here present, Judge at Maine. He declined the service of public defender.
Mr. Drusis, good morning, sir. You were charged with domestic battery. I have read the probable cause affidavit. I find probable cause. Do you live with Malassi Daniel?
No, sir.
Where do you live?
In Miramar, 2671 Southwest 84 Terrace.
Who do you live with?
See.
My mother.
Okay, I understand you have a daughter with the alleged victim. Am I correct?
Yes, Your Honor.
Who does she live with?
Shared custody through verbal agreement.
Okay. Are you legally married?
No.
No, Your Honor.
Okay, so you got the two of you kind of handle the custody of the child together, just on your own agreement?
Yes, Your Honor.
Okay, and where's the grandmother?
My mother?
Okay, where's your mother?
She's probably at work right now.
But I mean, you live with her?
Yes, Your Honor.
Okay. State. Mr. Druces, can you make $1,000 bond?
Yes, Your Honor.
Okay, so I'm going to set $1,000 bond. I'm going to order no contact between you and Malassi Daniel until further order of the court. And you're going to have to let your mother handle or coordinate the custody of the child, okay, until further order. Because you're not going to be able to have any contact with the mother. Do you understand that?
Yes, Your Honor.
Think you can do that?
Yes.
Okay. All right. Somebody will post $1,000 bond for you. You'll be out.
Thank you.
Brandon Baskin.
Mr. Baston, come on up, please.
Good morning, Mr. Baston. You are also charged with domestic battery. I've reviewed the probable cause affidavit. I find probable cause. Mr. Romero, I'll hear from you.
And speaking of Mr. Baston, he's been residing in our community for 26 years. He's 27 years old at this time. He's currently employed. He works for a moving company. He's been employed with the same company for 4 years. He makes approximately $20 an hour. The alleged victim is his girlfriend. He'll be living separate and apart from her. He'll be residing with his family who live in the community. His girlfriend and him do share one child in common who's 1 year old. Judge, what we'd be asking you is to consider setting a $1,500 bond on Mr. Basden's behalf, and also asking you to enter an order allowing through a third person to arrange for child visitation.
And who would that third person be?
Let me ask, Judge. It could be Mr. Basden's mother. So basically, any sort of communication dealing with the custody as far as child visitation would go through the mom, and for the exclusive reason just to arrange for pickup or drop off, things of that nature.
And they're not legally married, am I correct?
No, they're not.
Okay. State.
Your Honor, State would request a $1,500 bond, no victim contact.
Okay, so I'm going to set a $1,500 bond at the request of both parties. I'm going to order no contact whatsoever in any form or manner with the alleged victim until further order of the court. And arrangements for the child should be made through the third party, which will be through the defendant's mother. Thank you, sir. Anthony Martinez?
I believe he's on medical loan, Judge.
Okay, we'll reset him for tomorrow. Giovanni Castile? Mr.
He's here
Castile,
present, Judge.
you're being held no bond on a violation of probation from a case out of 2013. It's 13-001707 CF10A. You'll be heard before that judge on 4/24/17 at 9:45 a.m. Thank you, sir. Eric Roger?
Eric Broward, Your Honor.
Mr. Roger, good morning, sir.
Good morning.
Mr. Roger, you're being held on two charges. One is domestic battery, which I have read the probable cause affidavit, and I find probable cause. And you're also being held on a violation of community control or probation. You're being held no bond.
Yes, Judge. I was told that I could go to Brevard to release that bond.
Yeah, it's an out-of-county hold, Judge. Mr. Roger indicates to me that he's lived here all of his life. He believes his uncle can post a $500 bond for him on count one.
Okay.
If the court would consider a bond somewhere in that area, he can bond out on count one, go to Brevard County, resolve his violation of probation there, and then come back and take care of this.
Well, isn't the hold no bond?
Yes, they would come and get him if he was released on count one.
State, do you have any objection to that?
Yes, Your Honor. It's when, normally you see RORs on possession of cannabises, no valids on a domestic.
Asking for a $500
Oh,
bond.
Your Honor, I was going to be asking for 1,000. I'm sorry. I thought it was a request for
I'm
an
going
ROR.
to set a $500 bond on count one. Mr. Roger, if you make bond and if you're out on bond, I do not want you to have any contact in any form or manner with Justin Roger, the alleged victim in this case. Do you understand?
Yes, Your Honor.
Is there any reason you must have contact with him?
No, Your Honor.
Okay.
Hold on 1 second. Yes.
If you post a bond, then we'll get you transported, okay?
Probation.
500 on count one.
Yes, sir.
Probation.
Henry Chase?
Very much.
Mr. Chase, Henry Chase.
Henry Chase?
He's approaching, Judge.
Thank you very much. Mr. Chase, good morning, sir. You're being held no bond on a violation of probation in case number 15010-361 CF10A. You're set to appear before the judge on your violation of probation on April 24th at 9:45 a.m. Thank you, sir. Frank Henry? What do you want to get?
Well, I'm seeking no bond on the armed burglaries.
Mr. Henry's here, present, Judge at Maine.
All right, Mr. Henry, you are charged with domestic aggravated battery, which is a dangerous offense under the statute. I've reviewed the probable cause affidavit. I find probable cause. We're here to set bond. And Mr. Romero, I'll hear from you first.
Judge, if you could allow me 10 seconds, I just want to ask one question, Mr. Henry, so you could hear from the state first.
Okay?
Yeah, sorry, Your Honor, his criminal history, out of Dade County, 2008, possession of cocaine. He was picked up in Dade in 08 for failure to appear in court, arrested for battery in Dade in 07. That was dropped. 1 moment, Your Honor. 1992, out of Dade, robbery with a firearm or deadly weapon. 2 count, actually, 5 counts. Your Honor, based on his criminal history and the level of violence alleged in this, in the probable cause.
You said 5 counts of robbery. Those are pending?
No, there's from 1992 in Dade County, Your Honor.
I see, okay.
Based on his criminal history and the allegations in the report, Your Honor, state would be seeking a $7,500 bond and no victim contact.
Okay, Mr. Romero?
Judge, I just want to know, what was the disposition on the robbery from 1992?
They were all convictions.
Convictions?
Thank you, Judge. And speaking of Mr. Henry, Judge, he's been residing in South Florida for 35 years. He is 44 years old. At this, he's a single father. He has 2 children, ages 9 and 21. Both children are on disability, so he's the sole, I guess, provider. He takes care of both children. He's also has been experiencing serious health problems, and he's also in the process of applying for disability. Financially, he has really no sort of resources, Judge. He is looking for employment at this time. He's not currently working. He lives in Fort Lauderdale. He's a volunteer for his children's school. What he would be asking for is, and I know the prior that he has is concerning, but I would ask the court to take into account the time periods from 1992. So therefore, considering this gentleman's criminal history as far as being dated, his strong ties to the community, his lack of financial resources, I would ask you to consider a $1,500 bond plus pretrial, Judge.
He is not working now, presently?
At this time, no. He's actually volunteering at his children's school, but he filled out an application. He thinks that's going to go well. He's going to start soon to be able to work. But at this time, no, he is not working, Judge.
Okay, and does he live with the alleged victim?
No. The alleged victim, my understanding is she came over to his place just for one day. She actually lives in Miami. So they live separate and apart, have no business having any sort of contact. They don't share any children in common.
Okay, what I'm going to do is set a $3,000 bond and level 2 pretrial release with a monitor.
So that's $300.
Order no contact in any form or manner with the alleged victim until further order of the court.
So $300 for pre-trial.
I'm going to ask that you waive that on this particular case. Ladies and gentlemen, it seems very loud in here. I'm having difficulty hearing everybody.
Judge, it's,
Oh, is that what it is?
yes.
Sorry, guys. It's a $3,000 bond, level 2 pretrial release with a GPS and no contact. And Calandre Williams?
Judge, I'm being asked by one of the deputies if we can take a gentleman out of turn.
Okay.
The gentleman's name is Neville Henry. He is on page 15 of the docket, so he's towards the middle.
Okay, just give me 1 second to find it.
Yes, Judge. Judge, he declined the service as public defender.
Okay. I've got it here. And
Yeah.
okay, Mr. Henry, good morning, sir. You are charged with You are charged with aggravated a battery on a person 65 years of age or older. State, is that a I know it's a dangerous crime, but is it a first-degree punishable by life?
It's not punishable by life.
Okay. I have read the probable cause affidavit. I find probable cause. So we're here to set bond. And Mr. Romero, my understanding, he's declined the services of the public defender.
Actually, no. He changed his mind. We're going to be represented. If I can have 10 more seconds.
Take your time. I'll hear from the state.
Your Honor, Mr. Henry's already being held on charges of aggravated battery and corruption by threat. His bonds on those counts are $10,000 and $5,000. Additionally, Your Honor, sorry.
Do you happen to have the PCs on those?
I can get that for you right now.
What I would need is,
Well, this one, just so you,
wait a minute. I have the probable cause affidavit. This is the subsequent offense, right?
yeah, this, and I don't know if this was the court's curiosity. This wouldn't violate. This happened before.
No, but
okay.
what I'm considering is revoking his pretrial release on the initial case.
And the problem, Your Honor, he can't because he was already, he received his release conditions before this occurred. I mean, after this occurred. This doesn't violate his release conditions.
Okay,
They were still investigating this when he was arrested.
I
So,
understand. Got it.
Your Honor, just to let you know, he has last year felony theft. He's had, let's see, 1, 2, 3, 4, 6, 8, 9, 10. 10 more thefts since 2012, a battery in 2015. In light of the fact that his other aggravated battery received a $10,000 bond, and the age of the alleged victim in this matter, I'd be asking for a $10,000 bond, no victim contact.
Okay, Mr. Romero?
Judge, yes, and speaking to Mr. Henry, as this prosecutor indicated, he has other cases and he has other bonds. Financially, he can't afford to post those bonds. That's why he's still here in custody. He lives in Lauderhill with his father. He's currently working at the swap shop, making minimum wage. Basically, at this time, he's financially indigent. What he's requesting, Judge, is for you to consider pretrial release.
Okay, I'm going to set a $10,000 bond. If he is released, I'm going to order that he be placed on level 1 pretrial release house arrest with a monitor, and he is to have no contact in any form or manner with Willoughby Glassforty, the alleged victim in this case. Thank you, sir.
Judge, can you appoint us on Mr. Henry's case because we're not able to get him to sign any paperwork?
Well, I can't really appoint him unless he is declared indigent, right?
That's true, Judge, but he is in custody.
I'll tell you what I'll do is I can appoint you for the purpose of this proceeding, and then it can be reviewed at arraignment.
That's fine, that's fine.
I need my people here, okay? Could I have that back? You got it.
Judge, Mr. Henry would like to address the court. I advise him not to talk about the facts of the case. He said he's not going to talk about the facts of the case.
Okay.
He just wants to make a request.
Okay.
Yeah, sir, I am a working man, sir. I'm not going to speak about the case. I'm trying to get out on a pre-trial release or RR, anything, sir, to help me out to get out of jail today, sir. I'm trying to work. You know, I'm a working man. It was a mistake what I did. I'm not going to speak about the case.
Don't
but,
say
sir,
anything about the facts of the case, such as it was a mistake. Don't even put yourself on the scene, Mr. Henry.
Okay.
Yeah, I understand that, but Judge,
You know what I'm saying?
am trying to get out of jail today. Even if you put me on the ankle monitor, I will appear to court. I live in Lottie Hill, sir. I am a working man. I'm trying to get back to work, sir.
Okay.
I'm trying to get back to work. I don't have nothing.
Mr. Henry.
I have problems, sir. Jail is not going to help me. Jail is not going to help me. I need to get out of jail. This will only make me worse.
Okay. Mr. Henry, under the law, I have to set a monetary bond. I am going to set the bond at the request of the state. I think that it's appropriate. And if you are released, I need for you to be on house arrest until this case is resolved. Thank you very much. Calandre Williams?
Your Honor, if we could put this on a brief recall, he's represented by private counsel who's going to be coming forward.
Calandre Williams, I'll put on recall. Jason Brown? Jason?
Jason Brown, come on up, please.
Good morning, Mr. Brown. You're being held on a violation of probation, no bond on case number 11-011419 CF10A. You are scheduled to appear before the judge on April 24th, 2017 at 9:45 a.m. Thank you.
Ms. Boynton, come on up, please.
What happened to Calandre Williams?
Ms. Boynton, good morning.
Young man,
You are charged with a simple battery. I have reviewed the probable cause affidavit. I find probable cause. Your bond is presently set at $1,000. Can you make that?
No.
Judge, I have information to share with Your Honor.
Okay.
In speaking with Ms. Boynton, she's 25 years old. She's been living here her whole life. She's currently employed. She works for Comcast. She just obtained her employment. She's scheduled, her start date is going to be May 1st. She's going to be in customer service, making approximately $12 an hour. So at this time, she has no sort of financial resources to post bond because she's just starting to work. She lives at West Park. The alleged victim and her...
Mr. Romero, let me cut you off just for a moment. Let me hear from the state just for a moment. I'll get back to you if I need it.
Your Honor, she has, I see no criminal history. I'll leave the bond amount in the court's discretion. I'm just asking that there be a no contact order.
Okay, I'm going to release her on standard pretrial release. She is to report by phone once a week. She is to report in person once a month. She is to have no contact in any form or manner with the alleged victim in this case. Ma'am, do you need to have contact with him?
No.
Do you have any children together?
It was my sister. It wasn't a man.
Oh, I'm sorry. You're correct. I'm sorry. Okay. You don't live together, right?
No, we don't.
Okay, so no contact until further order of the court, okay?
Yes, sir. Thank you.
You'll be released
Your Honor,
today. Once you get released,
Possible,
you go
if we could call, this is a case that I discussed with counsel, if we could possibly call it out of turn. Mario Perez, page 21, towards the back.
Like 8 from the bottom, Your Honor.
Oh, great, that helps me. Thank you.
Good morning, Judge. John Hager on his behalf.
Mr. Hager, good morning.
Perez,
I don't...
your attorney's here,
is
present.
Mario Perez?
Mario Perez, page 21.
I apologize for, but...
No, that's fine. I understand. I apologize.
I need these people all the time.
That's not a problem.
Okay, so on Mario Perez, good morning, sir, how are you?
Good morning, Your Honor.
Judge, we're asking that this...
I just have to go through a little dialogue. Mr. Perez, you are here charged with aggravated assault with a deadly weapon without intent to kill, a simple battery, aggravated battery with a deadly weapon, burglary of a structure or conveyance armed. I believe it was an automobile. And a second count of the same thing. You're presently being held no bond on the 2 first degrees punishable by life. And I have reviewed the probable cause affidavit, find probable cause, so we're here regarding bond, counsel.
Judge, we're just asking for bond on counts 1 and 3. Counts 4 and 5, we're going to have an Arthur hearing in front of Judge Usan. That's the division judge. So I know the state needed more time, but to speed it up.
I spoke with counsel, so we're just going to forego, and the counsel will seek the Arthur hearing in front of Judge Usan.
Okay, and what about, right now the bond is set at $1,000 for the simple battery.
Right, that's
as
fine.
to the other 2 counts?
Your Honor, he has no history, Your Honor. Your Honor, I would be requesting $15,000 bonds on 1 and 3.
And what are you requesting, sir?
Judge,
Not that it makes any difference.
I understand. He's going to have presumably a higher bond on the other counts when it goes to Judge Usan, asking for a lower bond on counts 1 and 3 as to $5,000.
What I'm going to do is set a $10,000 bond on count 1, a $10,000 bond on count 3, and we'll let you file the motion before the division judge. Okay?
Yeah, I will.
Okay.
I'll see my client in custody.
I'm sorry, Your Honor. Also, we would obviously ask for no victim contact and an additional condition that during the pendency of the case, Mr. Perez not be in possession of any firearms or weapons.
Okay, Mr. Perez, by the way, I believe that there are 2 alleged victims in this case. I'm ordering that you do not have any contact in any form or manner with those 2 alleged victims. And during the pendency of these proceedings, you cannot possess any firearms. Do you understand, sir?
Yes, Your Honor.
Okay, thank you very much.
Thank you.
Your Honor, what did he just place on? Another case I was hoping counsel is present. Augustina Price on page 7. 7, towards the front. Price, Augustina Price.
It's like the 3rd one down.
Ms. Price, you're a private attorney, sir?
I've got it. Ms. Price, good morning.
Good morning.
You are here charged with exhibition of a weapon on a school property. I reviewed the probable cause affidavit. I believe it involves a taser, so I find probable cause. We're here for a bond.
Judge, can I,
Yes, sir.
with all respect to this court that I've known for 18 years, there's nothing that indicates Ms. Price came onto the school property with a taser. There's nothing that indicates the distance of the parking lot from the school, much less whether the parking lot is on school property. It doesn't seem to make that clear in this probable cause affidavit. But if Your Honor still believes that there's probable cause, which is your prerogative, I would ask that she be released ROR. She's an 18-year-old youngster, never been in trouble before, seeking admission into the armed services of the country. Her mother works as a nurse's aide in a hospice, and I would ask ROR and perhaps a curfew. In other words,
Can I ask you, what is the relationship between her and Robert Mitchell?
I would assume that it was girlfriend and former boyfriend.
Okay, they're not living together, they're not married?
Ms. Price, are you guys living together? I don't think so. So I believe she lives with her mother.
Well, let me hear from her. Ms. Price, can you hear me?
Yes, I don't live with him, no. I live with my mother.
Okay, is there any reason that you need to have contact with him?
No, not at all.
Okay.
The only other thing, Your Honor, if the court could inquire, does she go to the high school, this Credit Plantation High School? Is she a student there?
Do you attend the school, ma'am?
Well,
Yes, I do attend the school.
The problem, yes, she does, and no, she doesn't. She will not be allowed back onto the school. The school policy is expulsion if you're charged with a crime. She will have to find one of those alternative schools in order to graduate, which she's supposed to do this semester, and then seek entry into the armed services. I don't have the name of the recruiter or the phone number, but the mother does.
That was just going to be my issue, just not going back onto the campus. Your Honor, whatever the court, I mean, I was going to be requesting pretrial release supervision.
I'm going to grant that. Ms. Price, I'm going to place you on standard pretrial release. You're going to, upon your release, you're going to have to report to pretrial release, and they'll go through all of the requirements with you. You're going to need to report by phone once a week and in person once a month to pretrial release while this case is pending. Also, you are not to go back onto the property of Plantation High School while this case is pending. And you're to have no contact in any form or manner with Robert Mitchell. Do you understand everything?
All right, burn up.
Yes.
Okay, do you have any questions?
No, not at all.
Okay, thank you, everybody.
Thank you, Judge.
Okay.
I can go now.
It's ROR to pretrial, I'm sorry, thank you.
And, Your Honor,
Yes.
Calandre Williams, I think we can proceed now.
Morning, Judge.
Mr.
Williams?
No, I'm ready.
I got it right here. Okay.
Your private counsel's here, President?
Morning, Judge. I'm sorry I'm running late. I'm really sick today.
Yeah, I can hear a little bit in your voice. I'm glad you're way over there.
Yeah, I think it's on the downside of it, thankfully.
I hope you feel better.
Okay, well, I'm here for Calandre. I
Okay,
made it for you because I'm sick, Calandre.
Okay, let me go through and advise him of what he's charged with. Mr. Williams, you are here charged with domestic battery by strangulation and one count of domestic battery. So there's 2 counts. I've reviewed the probable cause affidavit, find probable cause, and so we're here to set bond, and I'll hear from Mr. Weinstein.
Judge, first and foremost, the victim is here. She's present. She's right next to me.
Okay.
So that's very important for the court to know.
All right.
A few things you need to know about Calandre Williams. He called, when the detective called him and said, I have probable cause for your arrest, he said, okay, I'm going to hire a lawyer. He called me, and the detective said, you have to surrender. This gentleman, on his very own, drove over to the jail and said, I want to surrender. They said, nope, it's a probable cause arrest. You have to go to Hollywood. So he then got in the car and drove to Hollywood, knowing that there was a pending felony charge out there, and surrendered himself. So clearly he's not a flight risk. That's number one. Number two, Calandre is a U.S. citizen. He's born here in Miami. He has a steady job, and he's licensed in the state of Florida as a security agent. So he's got strong ties to the community. Third thing, his girlfriend came to see me yesterday. She's here. She's going to testify. She is not in fear of him. She does not want to prosecute him. She wants him to be out immediately. She doesn't want him to pay bond. She doesn't want him on pretrial. As the victim, she is completely okay with him getting released.
Okay, ma'am, could you come forward, please? If you would raise your right hand, do you swear to tell the truth?
Yes, I do.
Please put your arm down. Please state your full name.
My name is Janice Tiffany Davis.
Okay, you're going to have to speak up a little bit because I'm getting old.
My name is Janice Davis.
Okay, and ma'am, where do you live?
I live in Miami Gardens.
And who do you live with?
My grandfather.
Okay, and what is your relationship to Calandre Williams?
Boyfriend, girlfriend.
How long have you known him?
I've known him for about 9 months.
Okay, and as you stated, you don't reside with him, right?
No.
Okay, and are you in fear of him if I was to release him?
No.
Do you want to have contact with him, or do you want me to order no contact?
I would like to have contact.
Okay, has this ever occurred before?
I'm sorry?
Has this ever occurred before?
No.
Okay, state any questions?
Yes, Ms. Davis, you gave a sworn statement to law enforcement about what occurred?
Yes.
And as a result of this incident, you sought medical treatment at the hospital?
Yes.
Mr. Edgemar?
Your Honor, I'm not going to go into any more detail at this time.
What is your recommendation?
Your Honor, and I understand that the alleged victim is here today saying she's not in fear and wants contact. That being said, I have a concern for her well-being based on these allegations. Your Honor, I'm going to be asking for a $7,500 bond on count 1, a $2,500 bond on count 2. No victim, and I am going to be requesting no victim contact.
Ma'am, could you make that bond for him?
I think that's going to be a little high. I don't want to speak. I know you asked her, but
Okay,
Judge.
yes. Mr. Weinstein, what are you looking for?
Judge, I was going to ask for an ROR with standard pretrial because, again, strong ties to the community and a self-surrender and no prior criminal history whatsoever.
That's granted. That motion is granted. I am going to release him ROR on both counts with standard pretrial release. He is to report by phone twice a week. He is to report. Report in person once a month. And I apologize, ma'am, but in an abundance of caution, I feel it's imperative that he has no contact with you at this time. Mr. Weinstein can take this up with the division judge regarding the modification of this bond, but at this time, knowing little bit that I do, I'm going to order that he has no contact with you in any form or manner until further order of the court. Okay?
Judge, can I ask you to modify that and just ask for electronic or telephone contact only? Because there are some things that, you know, she is going to be a witness. I'm going to be able to need to contact her, coordinate court dates. If they could at least have phone contact, it might help.
Well, Your Honor, I have no objection with Mr. Weinstein being in contact with her, but I don't think that he needs to be in contact with her.
Well, my only, and let me go through this. I am concerned that he might start harassing you by telephone if I give telephone contact. Do you have any concerns about that? Do you want telephone contact with him, but no personal contact? Do you understand? Okay, so I'm going to grant that modification. Upon his release, he can have telephone contact with you. But if it becomes a point where you feel he's harassing you or stalking you, you bring that up to the division judge, okay? And then she can modify it.
Your Honor, I'm also going to be asking that there not be allowed to be any communication regarding this case, regarding the allegations of this case.
Well,
well, I mean, Your Honor, defendant shouldn't be.
I can instruct them. I'll instruct them not to talk about the facts of the case, but I don't know how much that's going to do.
Well, that's why I'm asking that there not be any contact, because
I'm going to grant the contact.
Thank you, Judge. Have a pleasant day.
All right. And he's Calandre Williams, right?
Right.
Okay, thank you. Okay?
Thank you, Judge.
Okay, can we start going? Mr. Romero, can we start going through the regular docket?
Yes, Judge.
Okay.
Thank you.
Christina Sargent?
North Broward, Your Honor.
Ms. Sargent, good morning. Ms. Sargent, you're being held on a violation of probation. The court set a $2,000 bond. You are set to go before the judge on April 20th, 2017 at 11 a.m. Okay, do you have any questions?
Yeah.
Okay, thank you. Karen Stevens?
Ms. Stevens, come on up, please. She's approaching, Judge. She's here at Maine.
Ms. Stevens, you are here on 2 counts of resisting without violence, 2 first-degree misdemeanors. I've read the probable cause affidavit. I find probable cause. Oh, I apologize. I misread that. I apologize. Ms. Stevens, you're charged with 2 counts of third-degree felonies of resisting or obstructing with violence. And I have read the probable cause affidavit. I find probable cause. So we're here to set bond. I'll hear from Mr. Romero.
Judge, what we're requesting is standard pretrial. The reason why we're requesting it is she's been living in South Florida for 37 years. She's a medical dispatcher. She's been steadily employed with the same company for over 5 years. She has no money in the bank, no property. She's a single mother. She has 2 children, ages 17 and 19, one in high school, one in college. She's the sole provider for them. She takes her 17-year-old to and from high school. She pays for her 19-year-old's college education. The 19-year-old currently resides with the mom. They live in Boynton Beach. They've been residing at the same...
Can I interrupt? Yeah. Why the maximum custody inmate outfit? What is that all about?
That was the...
Okay.
They'll advise you. I don't want to string it out.
Got it. Never mind. State, let me hear from you.
Your Honor, I was going to be requesting a $500 bond per count.
Okay, Ms. Stevens, I am going to release you on pretrial release. ROR you on each count on standard pretrial release. You're to report by phone twice a week, once a month in person. Where do you live, ma'am?
Boynton Beach, Florida.
Okay. All right, anything else?
Nothing else, Judge.
Thank you.
Mr. Cobbett.
You'll be released. Okay, ma'am. As soon as you get released, you have to go to pretrial. Here's the map, okay?
I have to go to bed?
Yep, today, as soon as you get released.
Angela Favorite?
Bonded, Judge.
Okay, thank you. Yvette McDonald Gardner?
Ms. McDonald Garner, come on up, please.
How could Favorite have bonded?
Because I believe
She got no bond hold.
no. It says on here,
Not
on the
applicable.
order signed by the judge, April 18th by release April 18th by 5 a.m.
I've got that she was remanded in the custody of bond, but okay.
Do you have this? Do you have this page?
Okay, I see that. All right.
Okay. All right. Miss Yvette McDonald Gardner, you are here charged with failing to stop or remain after an accident involving serious bodily injury. You're also charged with reckless driving, failing to provide liability insurance, and driving while license suspended. I've reviewed the probable cause affidavit. I find probable cause. So we're here regarding bond. And Mr. Romero?
Judge, I believe if the state can confirm this is her first contact with the system, what we'd be asking for is standard pretrial. She's 57 years old. She works at Jackson Hospital. She's a technician. She's been working for the hospital for over 15 years. Financially, she only has $100 in the bank. She lives in Miami. She lives in an apartment for over a year. She's been residing at the same residence. Her monthly rent is about $1,000. She lives with her boyfriend. She doesn't know if her boyfriend has right now the financial resources to post her bond, so that's why we'd be requesting standard pretrial.
It also appears in the probable cause affidavit that she turned herself in and responded to the Florida Highway Patrol Station.
All right. One, this is not her first contact with the legal criminal justice system. New Jersey, mid-'80s, she was convicted of aggravated assault. Late 90s and date, she was arrested for battery. That was dropped. Secondly, I understand that she eventually might have turned herself in. She's supposed to stay at the scene. She was driving with a suspended license and was in an accident where someone was injured. Additionally, Your Honor, and I understand that she's stating that she doesn't know what her means are, but I think the other factors outweigh outright release, Your Honor.
Could she make any kind of bond? Monetary bond?
In the contrary, she's going to call her boyfriend. She believes potentially her boyfriend might be able to come up with a $500 bond. So if Your Honor's not inclined for standard pretrial, then in the alternative, considering, as my colleague stated, she actually went to turn herself in, so she's not a flight risk, I'd ask you to consider then $500 bond, Judge.
Well, what I was going to do was set a $500 bond on count 1 and count 2. Release her ROR on the other 2 counts. I'm looking at her DL record. I don't see a prior arrest for driving while license suspended, but it is suspended at the present time.
Your Honor?
Yes.
I'm sorry. She did not turn herself in. In the first page, in the last paragraph, the trooper passed by the owner's address and made contact with her. She did not turn herself in.
No, I understand. Okay.
It says April 17th, 3:15 p.m., Ms. Gardner came to the Florida Highway Patrol Davies Station.
Okay, guys, that's not a defining factor.
That's what I've been informed, Your Honor. She went to the Highway Patrol yesterday to turn herself in.
Can she make the $1,000 bond?
Well, right now, she hopes her boyfriend can. So we're hoping then. Okay.
That's what
Thank
I'm
you,
going
Judge.
to do. $500 on count 1, $500 on count 2. I believe the third one is a infraction.
Yes.
And then the fourth one is ROR.
Thank you, Judge.
Okay, ma'am. Said Donna Rose.
Miss Rose, come on up, please.
Miss Rose, you are charged with burglary of an occupied conveyance, unarmed, and also charged with grand theft.
That should be petty theft, Your Honor.
You're right. You are correct. I read this and I thought that there was, and you're charged with petty theft, a misdemeanor. The bond for the petty theft is $100. I do find probable cause on both charges.
Kendrick, Rich.
I will hear from Mr. Romero regarding the bond.
Judge, what we'd be requesting is standard pretrial. If the state can confirm, This is her first arrest from what she's advising. Obviously, the state will look into that. She advised me she's a registered voter. She's 42 years old. She's unemployed at this time. She's collecting disability. She gets approximately $780 a month. She lives in Miramar with her son. Her son is 18 years old. He's attending high school. Judge, her monthly rent is about $1,000 a month. So therefore, her and her older son help come up with the rent amount. So therefore, there is no disposable income at the end of the month to afford any sort of bond, and that's why a reason that we're requesting standard pretrial. If the state can confirm, this is her first contact.
Your Honor, she has no record. This is from what I see, a second-degree felony. I would be asking that a bond be imposed. I would be requesting a $1,500 bond on count 1.
Judge, I believe it's just the burglary of a conveyance.
That was occupied.
Oh, it was occupied. Oh, allegedly occupied.
Okay. So it's a second-degree felony, right? And my understanding, it's a vehicle with an iPad.
I think a laptop, yeah.
Is she working?
No, she's on disability. She gets approximately, like I said, $780 a month.
Yeah.
Her rent is $1,000, so she's in the negative, and I believe her son tries to help her out, and that's why all their income goes towards 1 month of rent. There's nothing left over.
Okay, what I'm going to do is release her ROR on both counts to standard pretrial release. She is to report by phone twice a week, once a month in person. Thank you.
Okay, when you get out today, you have to go here. Here's the map. Just walk across the street, follow the map, okay? If you don't show up, they're going to issue a warrant. Okay. So make sure when you get released, you go straight there.
Yes.
Mr. Counselor? Counselor, sir, sorry.
You were home for cell phone number?
Okay, Mr. or Miss Christy Prasad?
North Broward.
Miss Prasad, good morning.
Good morning.
Can you hear me okay?
Yes.
Okay. Ms. Prasad, you are charged in count 1 with giving false identification to a law enforcement officer. Count 2, possession of heroin. Count 3, possession of drug paraphernalia. And then you are being held no bond on a violation of probation. And you're also being held no bond on 1, 2, 3, 4 capiases. Do you understand?
Yes.
You are scheduled to go before the judge on those cases on April 25th, 2017 at 8:30 a.m. I am going to ROR you on counts 1 and 3, and you have a $1,000 bond on the possession of heroin. Do you have any questions?
No, thank you.
Thank you, ma'am. Tamika Jean?
Ms. Jean is here, present, Judge at Maine.
Ms. Jean, you are charged with aggravated child abuse. I've reviewed the probable cause affidavit. I find probable cause. We're here regarding bond. Mr. Romero, what are you asking for?
Judge, what I'm going to be asking for is a $1,500 bond on Ms. Jean's behalf. And this is the reason why I'm asking. She's been residing here in South Florida since 1999. She's 32 years old. She's currently working at United Collection. She's a collection agent. She's been with the same company for 2.5 years. She lives in Pembroke Pines. Her monthly rent is approximately $1,350. She's been living at the same location for 2.5 years. She has 3 children. Because of the alleged incident, I believe DCF came. They took the children, and I believe she has a court date coming up with that, with family court. Hopefully they're going to develop some sort of case plan in order to reinitiate contact with their children. Therefore, I'd be asking, Judge, for $1,500 bond. I know you're going to be ordering no contact. I'd ask that it be allowed to be modified by any subsequent family court judge. And I believe her life partner is here present. That's who she's hoping is going to be able to afford to post the $1,500 bond.
I just add that I don't see anything in the probable cause affidavit indicating the age of the victim.
Yeah, it's the first sentence, I think. 11 years old, right? Am I thinking of the wrong one?
Your Honor, it's in the.
I am thinking of another one.
Below the affidavit, it has the alleged victim's information, including his age.
But the victim's name isn't mentioned in the body of the probable cause affidavit, so there's no nexus between the two.
Well,
it says person victim.
Okay, but anyways, state.
Yes, Your Honor, Your Honor, my position, even with family, even with ties to the community, job, and her ability to post bond, I'm sorry. The violence alleged in this case is just so aggravating that it just completely outweighs any mitigating factors, Your Honor. I'm going to be requesting a $20,000 bond, no victim contact. Additionally, Your Honor, I can tell you that she has priors. One moment. Federal prior out of 2008, possession of marijuana with intent to sell, distribute of foreign origin. She was placed on 2 years federal probation.
Okay, what I'm going to do is I'm going to release her ROR to level 2 pretrial release with a monitor. I'm going to ask that pretrial waive the cost of the GPS monitor. She is to have no contact in any form or manner with her 3 children until further order of the family court division. I will allow modification by that judge. And, okay, anything else?
That is all, Judge. Let me just explain to her as far as level 2.
Okay, thank you. I'm going to ask you guys to waive the cost of the monitor based on what I was told as far as her income. And she is a GPS and it's level 2. Okay. No contact. Right. Thank you.
Thank you, Judge.
Marissa Mesa?
North Broward.
Yes, sir.
Miss Mesa, good morning, ma'am. You are being held on a $5,000 bond for a violation of probation in 13001-775 CF10A. You are scheduled to appear before the judge on 4/20/2017 at 8:30 a.m. Do you have any questions?
No, sir.
Thank you, ma'am.
Thank you.
Okay, Fitzroy Morton?
Mr. Morton's here present, Judge?
Okay. Mr. Morton, you're being held on a capias in case number 17-001-408, MO48. Your bond is $100.
Judge, my understanding is Mr. Morton's been in custody for 30 days. I don't know if the state can confirm. He says that there's nothing else holding him at this time. Everything's been taken care of. I know on the docket this is count 3. But if there's nothing else holding him, everything's been taken care of, Mr. Morton, as a friend of court, he would like to resolve this case. This is a municipal ordinance case.
Okay, and let me see. It's charged with... Let's see, Judge Backman set the bond. Okay, let me see. It's loitering worse. Okay. Mr. Morton, do you swear to tell the truth?
Yes, sir.
You can put your arm down. Please state your name.
Fitzroy Morton.
Mr. Morton, it's my understanding you wish to resolve your case today, waive your right to an attorney and a trial. Is that correct?
Yes, sir.
Is anybody forcing you to do this?
No, sir.
Are you under the influence of any kind of drugs or alcohol today?
No, sir.
Ever been treated for a mental illness?
No, sir.
All right. Did you understand you're waiving your right both to an attorney and to trial?
Yes, sir.
Do you have any questions regarding any rights you're giving up?
No, sir.
And are you pleading no contest to one count of loitering in violation of, let me see, City of Hollywood Municipal Ordinance?
Yes, sir.
Court's going to accept your plea, find that it's freely and voluntarily given. The court's going to adjudicate you guilty on that case and order court cost of $78, and I'm giving you 6 months to pay that.
Okay, sir.
Thank you. You have any questions?
No, sir.
Okay, good luck to you, sir.
All right, thank you.
All right. Rico Thomas?
Conti, Your Honor.
Rico Thomas. Oh, Conti, Judge.
And look at, we
Good
have
morning.
Conte up. Okay.
Good morning.
Mr. Thomas, good morning, sir. You are charged with a violation of probation. The court has set a no bond in case number 12-014136 MM10A. You're set before the judge on that violation of probation on April 20th, 2017 at 1:30 p.m. Do you have any questions, sir?
No, sir.
Okay, thank you. Reginald Johnson?
Mr. Johnson's here present, main judge, municipal ordinance. He's also going to inquire if Your Honor would consider resolving his case today.
Okay, well, I will do this. I will resolve the one regarding no OSHA-approved vest, but I don't find any probable cause on the second charge of no roadway safety. I guess it's cones. I couldn't find anything on that, so I'm finding no probable cause. Mr. Johnson, do you swear to tell the truth?
Yes, sir.
And is anybody forcing you to resolve your case today?
No, sir.
Are you under the influence of any kind of drugs or alcohol at the present time?
No, sir.
Have you ever been treated for a mental illness?
No, sir.
Do you understand that you're waiving your right to an attorney and to trial?
Yes.
And do you have any questions regarding any rights you're giving up today in order to resolve this case?
I don't have any questions.
And are you pleading no contest to... Well, let me see. To one, a violation of the City of Pompano Beach Municipal Ordinance of not wearing an approved OSHA vest.
What about it?
Are you pleading no contest to that charge?
Yes, sir. No contest.
The court's going to accept your plea, find it is freely and voluntarily given. The court's going to adjudicate you guilty and order court costs of $78 on count.
How are you going to adjudicate me guilty when I plead no contest?
Well, no contest is like pleading guilty.
Well, I'm not pleading guilty.
Okay. Your bond is set at $25 on count one. I find no probable cause on count two, and I'm RORing you on that case. Thank you, sir.
Thank you.
And Clinton Massis.
Mr. Massis is here present, Judge. He advised me that he would like to bond out, but financially can't afford it. He's a pool cleaner. He lives in Fort Lauderdale with his grandmother. No sort of financial resource to post bond. He's asking, Your Honor, if you would consider an ROR.
I'm sorry to interrupt you. The bond is $25. You can't make that?
That's what he advised me. He can't afford it, Judge. He lives in Fort Lauderdale with his grandmother.
Okay.
And
just give me 1 second.
And
Okay, Mr. Romero, I'm sorry to have interrupted you. I just wanted to review his DL record. Go ahead, I'm listening.
That's our only request, Judge, if you would consider ROR.
Okay, Steve.
Your Honor, as you can see in his driving record, he has numerous failures to appear.
I am setting a bond at $500 on Mr. Massis after reviewing his DL record. Thank you, sir.
Judge, Mr. Massis is also asking if you would consider resolving this case today.
Well, it would be, right now, based on what I know and I have read, I don't know what would happen in the future, but if he wanted to resolve it now, I would be incarcerating him for 30 days. If he wants to accept that, I'll give him credit for time served.
All right, I'll get the case call. We can get you out of here. Oh, we're going to do the interpreter, so.
Okay, Adolfo Guerrero?
Judge, Mr. Massis wants to talk to Your Honor.
Excuse me, sir. Like you said, you got a little bit of my record. I'll take the 30 days to resolve this here. Get it over with. I just like to get it over with.
Okay. Mr. Massis, do you swear to tell the truth?
Yes, sir.
Please put your arm down. Please state your full name.
Clinton Massis.
Mr. Massis, it's my understanding you wish to resolve the case where you're charged with operating without a valid driver's license, a second-degree misdemeanor, and waive your right to an attorney in the trial. Is that correct?
Yes, sir.
Is anybody forcing you to do this?
No, sir.
Are you under the influence of any kind of drugs or alcohol today?
No, sir.
Ever been treated for a mental illness?
No, sir.
And do you have any questions regarding any rights you're giving up today, which include waiving your right to an attorney and a trial?
No, sir.
And are you pleading guilty to operating without a valid driver's license?
No contest. Yeah, guilty, whatever. Yes.
Okay, I'm going to accept your plea, find that it's freely and voluntarily given. I'm going to adjudicate you guilty, sentence you to 30 days in the Broward County Jail with credit for, today is what, the 18th? With 2 days time served. I also must order court costs of $293, and I will give you a year to pay that. Thank you, sir.
All right.
Adolfo Guillermo?
Mr. Guillermo, it's your present.
Mr. Guillermo, you are charged with criminal mischief.
Judge, we're going to need a Spanish interpreter on Mr. Guillermo's behalf.
Okay. All right, I'll put
Toma
that to the
asiento, por favor.
side. And we'll call one right now.
Yo entiendo que hay que estar claro, no tengo los contratos, no había los
Judge, Mr. Guillermo's advising me he's bilingual.
Okay. Mr. Guillermo, you are charged with criminal mischief under $1,000, over $200, and also disorderly intoxication. I have reviewed the probable cause affidavit, find probable cause. Your bond is, count one is set at $100, and your ROR on count 2. Okay?
Your Honor, just ask for no victim contact.
Victim contact?
Looks like they live close to one another, so.
Oh, I see. Okay. Mr. Guillermo, as a condition of your bond, you're not to have any contact in any form or manner with the alleged victim, in this case, Ilana Oliveira, okay? Until further order of the court. Thank you, sir.
Thank you, Judge.
Hector, do we?
Yeah,
Wait, hold on.
We need one for another case. So. Also, so you know, just let me.
Adrian Bermudez? Mr. Bermudez, you are charged with, well, you are here on a capias. Your bond is set at $100 by the judge, by the court. In case number 17-005476-TC10A, you are set to appear before the court on April 20th, 2017 at 10 a.m. Do you have any questions, sir?
No.
Okay, and your capias is for failing to show at arraignment. Thank you.
Judge, Mr. Bermudez is asking if Your Honor would consider resolving his case today for time served.
Order.
I never got that letter.
What's that?
No, I would not.
Thank you, Judge.
He is charged with, what I'm saying is I would not agree to time served.
Okay, thank you then.
Thank you. Tony Davis?
Mr. Davis, approaching judge is a municipal ordinance. He's also asking if you would consider resolving his case.
Mr. Davis, I would. Do you want to resolve it today and waive your right to an attorney in the trial?
I don't need an attorney. I attorney myself, and I want to plead no contest.
You just want to resolve it?
Yes, sir.
Okay, do you swear to tell the truth?
Yes, sir.
And did you say that you are also an attorney?
No, I want to represent myself.
You want to act, okay, as
attorney.
your own attorney. I understand.
I understand.
Is anybody forcing you to resolve your case today?
No, sir, this is my own free will.
Are you under the influence of any kind of drugs or alcohol right now?
No, sir.
Ever been treated for a mental illness?
Yes, I have.
And are you presently on medication, taking medication?
No.
The fact that you suffer from this illness, is it preventing you from understanding what we're doing today, the proceedings today?
No, I'm coherent.
And do you understand you're waiving your right to an attorney into trial?
Yes, sir.
Do you have any
Okay.
questions regarding any of the rights you're giving up today?
No questions at all, Your Honor.
Okay, and are you pleading no contest to one count of a violation of the City of Fort Lauderdale Municipal Ordinance of soliciting?
Yes, sir.
The court's going to accept your plea, find that it's freely and voluntarily given. The court's going to adjudicate you guilty and order that you pay court costs of $78, and I'm going to give you 6 months to pay that.
I thank you, sir.
Okay, thank you, sir. You're all done.
Have a nice day.
Richard Founds?
Let the judge know also.
Mr. Founds,
Yeah,
good morning,
Judge.
sir.
Good morning.
You are here for several outstanding capiases. The judge in those cases has set a bond of $100, and there are 5 counts, so it's a total of $500.
Is there any way to resolve this today, Your Honor?
Okay, let me take a look. Okay, do you swear to tell the truth?
Swear.
Please put your arm down. Please state your full name.
Richard Founds.
Mr. Founds, it's my understanding you wish to resolve all of your charges today, waive your right to an attorney into trial on each of those cases. Is that correct?
That's correct, sir.
Is anybody forcing you to do this?
No, sir.
Are you under the influence of any kind of drugs or alcohol today?
No, sir.
Ever been treated for a mental illness?
No, sir.
And do you understand you're waiving your right both to an attorney and a trial?
Yes, sir.
Do you have any questions regarding any of the rights you're waiving?
No, sir.
And are you pleading no contest in case number 17-001-362 MO48 to
Yes.
panhandling?
Yes, sir.
And are you pleading no contest in case number 17-001-355 MO48 to panhandling?
Yes.
And are you pleading no contest in case number 17001-042 MO48 to panhandling?
Yes, sir.
And are you pleading no contest to 17-000-940 MO48 to a violation of the City of Fort Lauderdale Municipal City of Hollywood Municipal Ordinance of lodging on city property?
Yes, sir. I'm waiving it. Yes.
Are you pleading no contest?
No contest, sir.
Okay. And in 17-001-374 MO48, are you pleading no contest to soliciting or panhandling?
No contest. Yes, sir.
Okay. The court's going to accept your plea, find that it's freely and voluntarily given. The court is going to adjudicate you guilty in each of those cases, order that you pay court costs of $78 in each of those cases, and I'm going to give you a year to pay that. You can make periodic payments to the clerk. Do you have any questions, sir?
No, sir.
Okay, good luck to you.
Your Honor.
Thank you, Your Honor.
If you could call a case out of turn, I see the Spanish interpreters here. There's a reset from yesterday, Juan Gonzalez Pena.
Juan Gonzalez? Señor, ven aquí.
It's labeled as, it was just a reset, but it's labeled as a perfection. Does the clerk, Madam Clerk, do you have?
The last page. Yeah, the last page on the docket, so it should be the last page.
So it should be the last case? Okay. Okay, so, Mr. Interpreter?
Yes, sir.
You have to forgive me, I just forget your name, I'm sorry.
Gabriel Sinisi.
Mr.
Sinisi.
Sinisi, of course. Mr. Sinisi, do you swear to translate from English to Spanish and Spanish to English?
I do, Your Honor.
Okay, and Mr. Gonzalez?
Señor González.
Can you hear me, sir?
¿Me puede escuchar, señor?
No lo entiendo, no hablo español. Hablo español. Sí.
¿Me puede escuchar?
Sí.
Yes.
You are here charged with burglary.
Está aquí acusado de
with an
arrendamiento
assault
con
or
fines
battery,
ilícitos,
which my understanding is a first-degree punishable by life.
agresión y lesiones, lo cual entiendo que es un delito punible por cadena perpetua.
And you're also charged with battery.
Y también es acusado de lesiones.
If you'll give me a moment,
si me da un momento,
I need to read the probable cause affidavit.
Necesito leer el atestado policial.
I'll be right back with you.
Y ya regreso con usted.
Here, let me give the post-it back. No, I get.
I have read the probable cause affidavit. I find probable cause.
Your Honor.
Presently set no bond on count. Yes.
I'm sorry to interrupt. I was hoping, Detective O'Malley is present. He was the lead investigator, and I understand the court found probable cause. I was hoping there's some additional information you can provide, and I was hoping to put that on the record. My concern is if a writ is filed and there's a de novo review by the 4th ECA, I would like to provide as much information on the record as possible, if that's okay.
Sir, if you'll come forward.
Tengo el detective aquí que es fue el.
And if you'll raise your right hand, do you swear to tell the truth?
Yes, sir.
Please put your arm down. Please state your full name.
Ryan O'Malley.
And who do you work for?
The Broward Sheriff's Office.
State.
Your Honor, if I, one moment, I see get my probable cause.
Si pudiera levantar la derecha, prestar juramento, sí, juro decir la verdad. ¿Y para quién trabaja? Para la policía, ¿cuál es su nombre? Ryan O'Malley.
Detective O'Malley, you were the assigned lead investigator for an alleged burglary with assault or battery that occurred, I believe, on April 16th of this year in Pembroke Park?
That's correct.
If the interpreter may interpret.
Yeah.
No, because
Yeah, of course.
Usted fue el investigador principal por un caso en Pembroke Park de agresión y lesiones el 16 de abril. Sí.
Would you please, and as part of your investigation, were you advised of what occurred with regard to this alleged incident?
Si podría, por favor, con respecto a la investigación, ¿y usted sabe qué ocurrió con este alegado incidente?
Yes, I was.
Sí, se me informó.
And how did you receive this information?
¿Y cómo recibió esta información?
From the deputy that took the report, Deputy Reyes.
Okay.
Del oficial, el oficial Reyes que tomó el informe.
And did you also take any sworn statements?
¿Y también suscribió algún tipo de declaración juramentada?
Yes, I did.
Sí, lo hice.
Who did you take sworn statements of?
¿De quién tomó las declaraciones juramentadas?
From the victim, Lillian Gonzalez, and from her children.
De la víctima Lilian González y sus hijos.
And have you had an opportunity to review the probable cause affidavit prepared by Deputy Reyes?
Yes.
¿Y tuvo una oportunidad de revisar el atestado policial preparado por el oficial Reyes? Sí.
And is that consistent with the information you received as to how this incident occurred?
¿Y eso es constante con respecto a la información que usted recibió de cómo ocurrió este alegado incidente?
Yes.
Sí.
Just a few other things.
¿Cosas más?
One, did the alleged victim advise you if she ever gave permission to Mr. Gonzalez-Pena to enter her residence?
¿Alguna vez le informó usted la víctima que ella le dio permiso al señor González Peña para entrar a su residencia?
No.
No.
Has he ever, based on the information you received, has he ever resided there? Was he ever given a spare key to the residence?
Basado en esa información, ¿alguna vez él residió o sea, alguna vez se le dio una llave extra para la residencia?
According to the victim, he's never been inside the residence before.
De acuerdo a la víctima, él nunca ha estado dentro de esa residencia anteriormente.
Would you please advise the court how the alleged victim identified Mr. Gonzalez-Pena?
¿Podría, por favor, informar al tribunal cómo identificó a la alegada víctima al señor González Peña?
A show-up was conducted where she identified him as a neighbor that she knows from passing.
Por un muestreo se verificó que él era un vecino que ella conocía al pasar.
And approximately how much time passed between the alleged incident and when she identified him?
¿Y aproximadamente cuánto tiempo transcurrió entre el alegado incidente y el momento que ella lo identificó?
About an hour to an hour and a half.
Entre una hora y media.
And where was he? When law enforcement came into contact with Mr. Gonzalez-Pena, where was he located?
Y cuando entró en contacto las fuerzas del orden con el señor González Peña, ¿dónde se encontraba?
He was located in his residence, which she also pointed out as the location that she saw him go inside.
Él estaba ubicado en su residencia, la cual ella también pudo ubicar que ella lo vio a él entrar allí.
How far is Mr. Gonzalez Peña's residence from the alleged victim?
¿A qué distancia se encuentra la residencia del señor González Peña de la alegada residencia de la víctima?
It's on the same street that she is, a few houses down.
Es la misma calle, a unas casas de distancia.
And did the alleged victim give any additional information with regards to the identity of the person that, Mr. Gonzalez Peña, the person that committed this offense?
¿Y la víctima dio alguna otra información con respecto a la persona que perpetró el hecho, el señor González Peña?
More specifically, any information with regards to what he was wearing?
Más específicamente con respecto a qué es lo que él vestía.
She said that he was wearing shorts, a t-shirt, and a hat.
Decía que él estaba usando pantalones cortos, una remera y un gorro.
Any specific information about the hat?
That it had a
¿Alguna información específica con respecto al gorro?
And did she, go ahead.
There was a sticker on the front of the hat or something shiny.
Que tiene una calcomanía sobre el gorro o algo brillante.
And did she give details about the colors of the shirt and shorts he was wearing?
¿Y dio algún detalle con respecto al color de los gorros, del pantalón corto, del gorro que vestía?
I believe she said the hat was a darker color, like a black, and the shirt was a reddish color.
Creo que dijo que el gorro era un color más oscuro, negro, y el pantalón corto era rojo.
Just a couple of other things. You mentioned the show-up identification. How certain was the alleged victim in making the identification of Mr. Gonzalez Peña?
Usted dijo sobre un muestreo de personas. ¿Cuánto de seguro estaba la señora de hacer la identificación del señor González Peña?
I was informed by Deputy Reyes that she was 100%, and in my statement that I took with her, she confirmed that.
Yo estaba con el señor Reyes, que dijo que era un 100%.
Your Honor, just a couple more, please.
Regarding what?
Your Honor,
I've already found probable cause and it's a first-degree punishable life. I'm going to order him no bond on that, and I am leaving the bond on the battery at $1,000.
Your Honor, I understand that.
Sin fianza, y voy a dejar las lesiones en $1,000.
My concern is the Public Defender's Office has filed numerous writs of these type of cases, Your Honor, and if I don't get this information on the record now, I will not have an ability to at a later date.
What you're doing is you're trying to conduct an Arthur hearing, which I am not going to permit at a first appearance hearing.
Lo que ha ocurrido anteriormente, el abogado público ha presentado muchos escritos. If I may just have access to the record for a moment, Your Honor. Our office's position is that we would request that you do conduct an Arthur hearing at this time. Sí pediríamos que se lleve a cabo una audiencia de Arthur en este momento. Our position would be that based on the information available to the court this morning,
Nuestra posición sería que, basado en la información disponible al tribunal esta mañana,
which consists of a very brief probable cause affidavit and the testimony of the detective,
que es un acto policial muy breve y el testimonio del detective,
that this court could not find that proof is evident or the presumption is great, which would be the standard the court would have to find in order to hold Mr. Peña no bond.
que no es suficiente para que encuentre el tribunal que la presunción es grande y que es el estándar necesario para que lo detengan sin fianza.
And this argument is based on State v. Arthur and the Florida Constitution.
Y este alegato está basado en el Estado contra Arthur y la Constitución del Estado.
Furthermore, the state could have provided the court with a motion to declare an intent to hold Mr. Peña pre-trial,
También estaría presentando un pedimento para no detenerlo sin previo juicio,
in which case the only standard the court would have to meet this morning would be one of probable cause.
y entonces el estándar sería el de causa fundada o motivo fundado.
The case would then be reset for 3 days for an appropriate Arthur hearing.
Entonces el caso sería vuelto a fijar fecha para dentro de 3 días para una audiencia de Arthur apropiado.
Okay, thank you.
Gracias.
Thank you, everybody.
Gracias a todos.
Thank you for coming. Is there anybody else with a Spanish interpreter that we can
Let me ask. Yeah.
And, Your Honor, did the court order no victim contact on that case?
Yes.
Okay, thank you.
Thank you.
Español, ¿alguien habla español? No one else here at Main, Judge.
Judge, I had a little trouble communicating with Mr. Martin Torres Rivera, who's up at the North Broward Detention Center on page 16 of the court's docket.
Thank you very much. Let's go to him first before we let Mr. Sinisi go. And Martin Antonio Torres Rivera at the North Broward. North Broward, do you have Mr. Martin Antonio Torres Rivera? Good morning, sir.
Come on, Torres. Torres is right here. Torres Rivera.
Okay, thank you. Mr. Martin Antonio Torres Rivera, do you have any problem with the English language?
No, never did.
Okay, so you speak English fluently?
I do speak. I translate for occasion that goes against this nation.
Okay. The only reason I'm asking is the public defender here had indicated that he had a little trouble communicating with you. So we have a Spanish interpreter here. Do you think we need him?
No, don't need it.
Okay, let me just go through this. Okay, could you remain just... Mr. Rivera, you are here charged with aggravated battery with a deadly weapon.
The man was still taking food from the other people.
Don't talk about the facts.
Hey, fear the Lord. Serve the Lord with fear.
Mr.
To all
Rivera?
the judges of the earth.
Mr. Rivera, let me just finish what I'm saying, okay? And then we'll hear from you.
Okay.
I have reviewed the probable cause affidavit. I find probable cause. We're here regarding bond. And Mr. Reedy, had you have an opportunity to speak with him?
I did, Your Honor. Mr. Torres Rivera indicates he's been living here in Florida for 2 years. He suffers from a disability, a physical ailment for which he receives SSI, so he is not currently working. He has no money to post a bond. He has very limited resources. He's hoping that his brother is going to be able to post bond for him. I have his brother's number, and I'm going to be calling his brother later to see if that's the case. But I really wasn't able to ascertain what kind of financial resources are available from the family.
For 2 years.
He is.
Mr. Rivera, what kind of bond did you post? How much?
I got no money. Put me in prison then. I go there. I enjoy it.
Your Honor, I believe Mr. Torres Rivera poses an extreme danger to the community. In addition
I'm the oldest.
In addition to
I got brother Pedrito, Luisito,
in addition to this offense, which obviously alleges a high level of violence, Mr. Torres Rivera is a registered sex offender out of the state.
I know sex if I'm innocent. Always was, always will be.
Out of the state of New Jersey, Your Honor. He was convicted in 1993, aggravated sexual assault and endangering the welfare of a child. Additionally, I've got concerns about his future appearance in court. In 2008 in Dade County, he was convicted of failing to register or violating registration requirements as a sex offender.
Hey, that's a lie. They say I was a sex offender.
Of resisting.
A child molester. In Miami, they shoot me with tasers.
Oh, yeah.
They say I was a sex predator.
What do I need to order on that, Mr. Reedy?
For what?
They shoot me with tasers.
Your Honor, I believe the court has two options. You can order a mental health evaluation. And I don't know what the PD's position is. I believe the court, if you want to, can have court projects do an evaluation. I don't know if the
you're talking about competency, right?
Yeah.
As far as court projects. But what about the mental health
evaluation? Revelation chapter 12 verse 5 and Revelation chapter 12 verse 10 speak about me. In the 70 book by Holy Bible.
Which is the
I'm not Jesus.
The mental health court, but
this is ruler, kings of the earth.
They won't be able to. He can't go in there until the charges have been filed. You can also order having Baker Act evaluated if you so choose. Have him brought to the nearest receiving facility.
I have the right to defend. I got a temper like anybody else. Bother me or bother you.
Can I transfer this to mental health court? No.
They can't take it in mental health until the information's filed.
That's right. Okay, you're right.
What you can do, though, is what you can do is transfer him to the nearest receiving facility. You can set the bond. You can leave the bond and to ensure he'll come back before the court to have a bond set when he's cleared as a result of the Baker Act, whether they...
Okay, let me hear from Mr. Reedy.
Sure.
Mr. Reedy, what
Judge, we would oppose the court ordering any kind of psychological evaluation on Mr. Torres Rivera at this time. What our office does is we're going to flag his case, make our office aware of what has happened here this morning. We are going to send someone out to evaluate him ourselves to make certain that he's A, getting medication, and B, that if further evaluations are necessary, they would be done in a confidential setting rather than in one that is open to the state to use later on, open to the court to review later on. If he's going to be our client, then I think we have the right to have the first evaluation.
Okay. Mr. Rivera, I find probable cause in your case. I'm going to order set a bond at $50,000. If you are released for any reason, I am placing you on level 1 pretrial release with a monitor, house arrest, and I'm going to ask the Public Defender's Office to follow through with our discussion earlier. All right, thank you, everybody.
Your Honor, just on abundance of caution, I'd ask for no victim contact with the listed
And
victim.
if Mr. Rivera is released, he should have no victim contact.
Thank you, Judge.
In any form or manner. Thank you, everybody.
Deny me, I deny you for a living.
And Corey Butts?
Mr. Butts is here present, Judge at Maine.
Mr. Butts, good morning, sir. You're here being held on a $250 bond pursuant to a capias issued by the court in 17-005-103 TC-10A. You are scheduled to appear before the court on 4/25/2017 at 9 a.m. Do you have any questions, sir?
Oh, yes, I would like to resolve, if I could, sir.
Let me take a look at what the capias is about. Okay, Mr. Butts, you're charged with driving while license suspended. Let me just take a look at your DL record, which I have in front of me. Okay, Mr. Butts.
Yes, sir.
I want to let you know that you have 2 prior convictions for the same thing, driving while license suspended. One on 9/3/2015, the other on 11/3/2015. If you were to resolve this case by pleading guilty or no contest, or if you were to be found guilty by a jury or a judge, your license is going to be suspended for 5 years as an habitual traffic offender. Okay? So you might want to go before the division judge. There are certain programs by the state attorney's office involving what we call a DIP program or a misdemeanor diversion program that will help you prevent your license from being suspended for 5 years. Okay, do you understand that? But if you were to plead no contest today to it, your license is going to be revoked as an habitual traffic offender. Can you make the bond of $250?
No, sir.
Well, I can't. You're going to have to go before the judge on that case and try to resolve it with him or her, okay? Thank you, sir.
Could I just resolve it?
I just rather resolve it right now, Your Honor.
Well, do you understand what I'm telling you?
Yes, I do, sir.
Okay, if you'll raise your right hand, do you swear to tell the truth?
I swear.
Please put your arm down. Please state your full name.
Corey Demond Butts.
Mr. Butts, it's my understanding you wish to resolve your case today, waive your right to an attorney in a trial. Is that correct?
Yes.
Anybody forcing you to do this?
No, sir.
Are you under the influence of any kind of drugs or alcohol today?
No, sir.
Ever been treated for a mental illness?
No, sir.
And do you understand you're waiving your right both to a trial and to an attorney?
Yes.
Do you have any questions regarding any of the rights you're giving up?
No, sir.
Do you also understand as a result of your plea, your license is going to be suspended for 5 years as an habitual traffic offender?
Yes.
Knowing that, are you pleading no contest to one count of driving while license suspended with knowledge?
Yes, sir.
And that's in case number 17-005103 TC10A. The court's going to accept your plea, find that it's freely and voluntarily given. The court is going to adjudicate you guilty, sentence you to time served, which I believe is 2 days, and order court costs of $293, and I'm going to give you 6 months to pay that. You can make periodic payments to the clerk. Do you have any questions, sir?
No, sir.
Okay, thank you. Mario Romero. Mr. Romero, you are here charged with an assault on a police officer, but I believe it is a police officer. I believe that is a second-degree misdemeanor.
First.
First-degree misdemeanor. Your bond is presently set at $100. I have reviewed the probable cause affidavit. I find probable cause. Do you have any questions, sir? Okay, thank you. Thomas Rose?
I believe it's a medical loan, Judge.
Okay. So we set that for tomorrow. Thomas Rose. Taylor Wesson?
North Broward.
And, Your Honor.
Yes, sir.
Well, I'll wait till you. On its face, this is a punishable by life offense, but it's really, reading the PC, it should be an attempt.
I've got that written down.
Great.
Okay, so on Taylor Wesson, Mr. Wesson, you are here charged with attempted burglary of a structure.
Yes, sir.
Actually, it looks like burglary of a business-use vehicle.
Yes.
And it's an attempt. I have found probable cause by reviewing the probable cause affidavit, and we're here to set bond, sir. What kind of bond could you meet, you and your family or friends?
I'm here. I got other charges as well, and I'm trying to get one of my cases as a no bond already. I'm trying to get bond for that one. So right now my bond is $168,000, but I'm trying to get bond reductions and stuff like that so I can catch bond.
I'd ask for a standard bond in the case, Judge, something fairly reasonable. I spoke with Mr. Wesson. He knows he's not going anywhere right away. So, but if there's a bond on here that he could make, maybe $2,500, something like that.
Your Honor, he's out, and the bond amounts he shared are accurate. I mean, armed burglary, aggravated assault. He's the no bonds on a robbery firearm. Another a bat Leo. Your Honor, I think.
So he's got bigger problems than this. I'm going to set a $2,500 bond. Mr. Weston, I'm setting a $2,500 bond. Thank you, sir.
Thank you, sir.
Ruben Valcourt?
All right. Stand up.
I didn't get a chance to talk to him, Judge. There was trouble getting through earlier.
It's not a problem. I'll give you any chance that you need. Mr. Valcourt, good morning, sir.
Good morning.
Mr. Valcourt, you're here a grand theft of a firearm. It's a third-degree felony. I find probable cause after reading the probable cause affidavit. We're here regarding bond. Your bond is presently set at $1,000. Are you going to be able to make that?
Yeah, but I'm on probation, so I'm not gonna pay it. I violate probation.
Okay, thank you, sir. Your bond is set at $1,000. Christopher Marsewski.
Mr. Marszewski is here, Judge. I mean,
It's Marzuski, isn't it? Marcheski, I was sorry. Mr. Marcheski, you are here pursuant to a capias issued on 17003640 CF10A, and the judge in that case has set the bond at $1,000. You are set to appear before that judge on 4/20/2017 at 9 a.m. Do you have any questions, sir?
no, sir.
Okay, thank you.
April 20th, 9 a.m. You'll be seeing your
Richard
judge to grant
Pacatera?
I gotta check these.
He's in Paul Ryan, Judge.
Paul Ryan. Richard Pacatera?
The judge now.
Yeah, he's at PM court, sir. He went to AM court. I'm sorry. He said he went to AM court.
It's in this AM court?
He's probably being arraigned on this.
Yeah, he's at AM court.
Oh, he's in the division. Okay, thank you.
You're welcome.
Ezequiel Arcuta?
Mr. Arcuta is here, present, Judge. You define the service of public defender?
It's Arcaute, and his first name's Ezekiel.
Okay, Mr. Arcante, you are here pursuant to a warrant for violation of probation. The court in that case has set no bond. In case number 13-007519 CF10A, you also have an out-of-county hold on you. It looks like a civil division, probably a family matter, and your bond is $700. You are set before the judge for 4/24/2017 at 9 a.m. Do you have any questions, sir?
No, sir.
Thank you very much. Jimmy Akovakis?
Mr. Arkovec is approaching. Judge, he declined the service of public defender.
Good morning,
Good
sir.
morning, Judge Paul.
How are you?
Well,
Mr.
thank you.
Akovakis, you are here charged with possession of methamphetamine, third-degree felony. Your bond is presently set at $1,000. You're also charged with drug paraphernalia, and I am RORing you on that case. I have read the probable cause affidavit. I find probable cause. Are you going to be able to make that bond?
Yes, Your Honor.
Thank you very much. Good luck to you.
Thank you kindly.
Okay.
Down the middle.
John Bailey?
Mr. Bailey?
Mr. Bailey, you are here charged with trespass of an occupied structure. I have reviewed the probable cause affidavit. I find probable cause. Your bond is set at $100. You also have 2 warrants for violation of probation in the case of 14-010394 CF10A and 14-010599 CF10A, and the court in those cases have ordered no bond. You're presently scheduled to appear before the court on 4/20/2017 at 8:45 a.m. Thank you, sir. Marvin Brown? Mr. Brown, you're presently here before the court charged with grand theft, of felony of the 3rd degree. Your bond is presently set at $1,000. You're also charged with unlawful possession of the personal ID of another, possession of drug paraphernalia, and resisting or obstructing an officer without violence. Those are misdemeanors. I have reviewed the probable cause affidavit, find probable cause. Your bond in the grand theft is set at $1,000, and I am going to ROR you on the other 3 counts. Any questions, sir?
Judge, in speaking to Mr. Brown, he said financially he can't afford a post bond. He advised me, though, he lives in Oakland Park with his father. He's asking if you would consider pretrial release on his behalf.
Right now, out of Dade County, Your Honor. He was arrested last month, and he's on pretrial supervision in Dade.
I was gonna say his bond should probably be increased.
Okay. All right. So those cases are out of Dade County?
Yeah.
Okay.
He's got other priors too.
So, Mr. Brown, you have some holds on you out of Dade County for what, violation of probation?
No, he doesn't have a hold yet. He may, but at this time, there's no hold. It's just being brought to your attention so you know
All
that.
right, I'm leaving the bond at $1,000. Thank you.
Thank you, Judge.
Roderick Lovett?
Mr. Lovett's approaching, Judge. He declined the services of a public defender. He believes, well, he spoke to his family. His family's going to be hiring private counsel.
Okay, Mr. Lovett, you are here on two charges, one substantive charge and one violation of probation in which you're being held no bond. Do you understand what the charge is? Has anybody indicated that to you?
Yes, sir.
Okay. Do you have any questions about that charge?
Yes, sir.
And you understand that you're being held no bond on a violation of probation?
Yes, sir.
Okay, so I'm setting no bond on the first count.
Your Honor, I'm sorry if I may, in good faith, I've reviewed this. I've spoken to the officer in my office. We're asking that the court find PC for attempt on count one.
Okay.
Which would make it bond eligible. And as an officer of the court, Your Honor, I'm obligated.
Okay, so Mr. Lovett, the state attorney here in the courtroom is indicating that what they're going to charge you with is attempted, okay, as opposed to...
Well, I don't know what he's going to ultimately be charged with. I'm just asking the court to find PC for attempt at this time.
Okay, so they're asking me to find PC only for an attempt, which means it's a bondable offense?
That being said, Your Honor, I want to advise the court, as you can see what he's on probation for on count two.
What kind of bond are you at?
$250,000. In addition to the charge he's on probation for, he has a similar prior, Your Honor, in 2003. This will be his third offense of this nature.
Okay. Mr. Lovett, I am going to set a bond. I must set a monetary bond on that. Count one, I'm going to set it at $150,000. On count two, you're being held no bond. Thank you, sir.
And we'd ask for no victim contact, Your Honor.
Mr. Lovett?
Oh, Mr. Lovett. He's getting it.
Well, I mean, the other division's going to have to set
Well, Your Honor,
violation, right?
no, understand my concern, Your Honor, is people use phones, write letters, so even from the
Mr.
jail.
Lovett, you are also not to have any contact with the alleged victim in this case. You cannot text her, write her, anything like that, okay?
Yes, sir.
Thank you. James Bunn?
Mr. Bunn?
Mr. Bunn, you're being held on a violation of probation, no bond by the judge in case number 15-006364-CF10A. You're scheduled to appear before the judge on 4/20/2017 at 8:30. Do you have any questions?
Well, why did I violate? Do you think?
What's the nature of the violation, Judge?
Oh, well, I don't think I have the warrant here. Let me see.
It's there. It's
It was a possession of cocaine.
Failed to successfully complete treatment.
Okay.
The warrant is for failing to complete outpatient treatment and failing to pay costs of supervision, signed by Judge Michael Robinson.
Thank you very much, Judge.
Thank you. Arnold Jean?
Mr. Jean, come on up. Judge, he declined the services of public defender.
Okay, thank you. Mr. Jean, you are charged with aggravated battery on a person 65 years of age or older. I must set a monetary bond. I have reviewed the probable cause affidavit. I find probable cause. We're merely here to set bond at this point. What kind of bond could you make, sir?
Kind of bond?
Yes. What amount of bond could you make? Or your family or friends?
You talking about bailing out or what?
Yeah, how much can you?
A grand?
Okay.
10%, right?
Your Honor, Mr. Jean most recently went to a Florida State prison and was released in 2014 for possession of firearm or ammunition by a convicted felon and criminal mischief, discharging a firearm in public. Went to prison for tampering evidence in 2012. He also has a record out of the state of Georgia based on his criminal history, the level of violence alleged, and the age of the alleged victim. Your Honor, the state is going to be seeking a $50,000 bond and no victim contact, pretrial release level 2, with GPS level 2.
Okay, Mr. Jean, what I'm going to do is set a bond at $25,000. If you are to be released, you're to be released into the custody of pretrial release level 2 with a monitor. And you are to have no contact in any form or manner with the alleged victim, in this case, Monfilia Norellis. Thank you, sir. Well, if he's working, then I'm going to let him pay. Okay. Antonio Nelson?
Mr. Nelson's here present, Judge.
Thank you. Mr. Nelson, you're here charged with possession with intent to sell, manufacture, deliver cannabis. Your bond is set at $1,000. I find probable cause after reviewing the probable cause affidavit. And you are also being held no bond and a probation violation. You're set before the judge on April 20th, 2017 at 9 a.m. Thank you, sir. Patrick Burnap. Mr. Burnap, you are charged with grand theft. Your bond is set at $1,000. You're also charged with uttering a fraudulent or false instrument. Your bond is set at $1,000. I do find probable cause, having read the probable cause affidavit. Can you meet that bond, sir?
Judge, he's advised me no, he cannot afford to post bond. He has a valid address. He lives in Pompano. He's kindly requesting if you would consider pretrial release on his behalf.
2014, burglary of an occupied dwelling, he violated probation. 2011, burglary of a dwelling and theft, he violated probation. 06, grand theft and battery. He's got the priors. Frankly, based on his record, I think the court has to take with a grain of salt his claims that he can't afford bond. There's financial resources.
Okay, what I'm going to do is release him on level 2 pretrial release with the monitor. He is to pay for the monitor. As you know, level 2 he can work. And that would be on both counts. I'll ROR him to pretrial release level 2 with the monitor. Do you have any questions, Mr. Burnap?
No, sir.
Okay, thank you.
Thank you.
Eberly Adamar?
Mr. Adamar?
Mr. Adamar, pursuant to the probable cause affidavit, you're charged with possession with intent to manufacture, sell, or deliver cannabis. Your bond is $1,000. Also, you're charged with possession of drug paraphernalia and driving while license suspended. If you'll just give me a moment. Okay. That is looks to me as though it's a second-degree misdemeanor pursuant to your DL record. I'm going to ROR you on the drug paraphernalia and the driving while license suspended. I find probable cause, having reviewed the probable cause affidavit, and your bond is $1,000 on count 1, the possession. Can you meet that bond?
Judge, what he's asking is this is his first arrest. If the state can confirm it, he lives in Lauderhill. He's going to try and call his cousin to bond him out. He doesn't know if the cousin can come up with the whole $1,000. He's requesting if you would consider reducing it from $1,000 to $500 if this is his first offense ever.
Any objection, State?
Your Honor, I mean, frankly, I think the $1,000 is reasonable. If he doesn't bond out, that's what we have second looks for. They find 200 clear baggies, a scale. I suspect that there's income coming in through other means.
Yeah, I tend to agree with the state. I'm going to leave it at $1,000 and ROR on the other two. Thank you.
Yes, Judge.
And Curtis Harrington. Thank you. Mr. Harrington, you're here charged with robbery without a firearm or weapon. I have reviewed the probable cause affidavit. I believe, if I remember, involves a game?
Yes.
Okay. And we're here to set bond. What kind of bond could you make, sir?
If I could have 30 seconds to talk to him, Judge.
Okay, I'm going to talk to the state. State, any information?
Your Honor, he has a juvenile history, nothing involving anything like this. Based on the allegations, Your Honor, I'd be requesting a $5,000 bond, no victim contact.
Okay.
Thank you, Judge. Mr. Harrington he advised me he's been residing here his whole life. He's 18 years old. He's currently working part-time, dealing with boat lifts. He makes approximately it's a part-time job. He makes approximately $300 a month doing that. He lives in Sunrise with his father. He's currently going to school. He goes to Whittam Rogers High School. Judge, what he's hoping his family could go ahead and bond him out. What he's requesting, Judge, is you would consider a $1,000 bond.
What I'm going to do is set a $2,500 bond. Mr. Harrington, as a condition of your bond, you are not to have any contact whatsoever with Stephen McCall. Do you understand?
Yes, sir.
Okay, thank you. $2,500.
His mother was here already.
Okay. William Cobbett? William Cobbett?
Mr. Cobbett? Oh, he's coming, Judge. He's coming.
All right, thank you.
Judge, he declined to serve as a public defender.
Mr. Cobbett, you are here charged with possession of cocaine, a third-degree felony. Your bond is presently set at $1,000. And you're also charged with possession of drug paraphernalia, a misdemeanor, in which I'm going to release you on your own recognizance. I have reviewed the probable cause affidavit, find probable cause. Can you make the $1,000 bond, sir?
Yeah, right now.
Okay, thank you. Good luck to you.
Hey.
Daniel.
Okay. Mr. Dornan, how do you pronounce your last name? Doronin?
Mr. Dronin, you're charged with possession of alprazolam, a third-degree felony. Your bond is presently set at $1,000. You're also charged with possession of cannabis less than 20 grams, and also a civil infraction. I'm going to ROR you on the possession of cannabis. I do find probable cause, having reviewed the probable cause affidavit. Can you make the $1,000 bond, sir?
Yes.
Okay.
Yes, Judge.
Thank you, sir.
Thank you.
Stephen Hahn?
That's going to be medical.
North Broward? North Broward, Mr. Stephen Hahn?
That's a medical reset, Judge.
Medical reset?
Yes, it is.
Okay, we'll take care of it. Victor Ramirez?
I believe he bonded, Judge.
Okay, thank you.
Ridge Kendrick?
Kendrick?
He's approaching.
Good morning, Mr. Kendrick. Mr. Kendrick, you're being held no bond by pursuant to a warrant signed by the judge in case number 14006847 CF10A, and you're scheduled to appear before the judge on 4/20/2017 at 8:30 a.m. Thank you. And Giacomo Portanova? Mr. Portanova, you are charged with driving while license suspended, which in reviewing the PC affidavit, I find no probable cause. I could not find anything there. Maybe the state can help me. You're also charged with distributing or delivering heroin, which is a felony. Your bond is presently set at $2,500. And you're charged with possession of cocaine, Third-degree felony, your bond is $1,000. I do find probable cause on those two charges. Can you meet a $3,500 bond, sir?
Judge, what he's asking, he doesn't believe he can come up with the whole amount. He takes care of his mother and his 3 kids. What he's requesting is on count 2, if you could drop it from $2,500 to $1,000. So therefore, it would be $2,100 bond.
Well, I'm going to ROR him on the driving while license suspended because I don't find any PC on that. But State, do you have any objection to a $2,000 bond instead of $3,500?
Your Honor, this isn't. Does this pretrial show he's registered also? Oh, okay, he was playing out the child abuse. Okay. Again, Your Honor, in this case they found 20 baggies. He's driving a Mercedes utility vehicle. I have a hard time believing that there aren't financial resources. But again, this is a charge that if he doesn't post bond, that's the reason for having a second look. But I'm concerned that it's being presented to the court that he has no resources when he's driving a Mercedes SUV vehicle.
Defense, I'm going to leave the bond at $3,500 based on the probable cause affidavit and what I'm reading. ROR, I'm on count 1. And
thank you, Judge.
Aaron Neal?
Mr. Neal's approaching, Judge.
Mr. Neal, you're being held on no bond by a judge for a violation of probation in case number 14-004769 CF10A. You're scheduled to appear before the judge on April 24th, 2017 at 8:45 a.m. Thank you, sir.
Mr. Garcia Figueroa, come on up. Mr. Figueroa, Judge declined the service of public defender.
All right, thank you, sir. Mr. Figueroa, you are charged with possession of THC and possession of cannabis over 20 grams. Both are felonies. Your bond is set at $1,000 on each count for a total of $2,000. I have read the probable cause affidavit and find probable cause. Can you meet that bond, sir?
Yes, sir.
Okay, thank you very much.
Down the middle.
In the middle, man.
Markeith Yarborough.
Mr. Yarborough is here present, Judge?
Mr. Yarborough, you are presently charged with possession with intent to sell, manufacture, or deliver cannabis. I reviewed the probable cause affidavit. I do not find probable cause for that, but I find probable cause for possession of cannabis. I'm going to ROR you on that count. You're also being held on bonds of $250 on case number 16009236 MM10A, a bond set by the court, a $500 bond on 16009238 MM10A, and a $100 bond on 17001411 TC10A. If you can't make the bond, you're scheduled to appear before the judge on 4/20/2017 at 10 a.m. Thank you.
Thank you, Judge. So you ROR'd you on count 1, 500, 250, 100. That's $850, right? If you can't bond out, you're going to see your judge April 20th. So you have to wait for 2 days, all right? Thank you.
And Jason Colasser?
Mr. Colsner is approaching.
Mr. Colasser, you are charged with aggravated assault with a deadly weapon, which I believe is a dangerous offense under the statute, and criminal mischief, which is a misdemeanor. And I have found probable cause, having read the probable cause affidavit. We're here to set bond. And Mr. Romero, I'll hear from you.
Judge, I'm still talking, Mr. Colsner, if you could hear from the state first.
Okay.
And just for the record, I understand it was charged as aggravated assault. This reads as an aggravated battery, Your Honor. See, it claims he was struck in the face. But I'll leave. But I understand the charge is an ag assault. But
well, the driver broke window with a gun and hit Mr. Sanchez on the left side of the face. It doesn't read that he hit him with a gun.
I understand, Your Honor.
That's why I think that they're saying it was an aggravated assault.
See, I thought if it wasn't with the gun, then he would have been charged with battery, but well, he's charged with aggravated assault. That's that will.
Well, no, you're right. I mean,
yeah, no,
in that charge, but right now he's.
That being said, Your Honor, based on the level of violence alleged, Your Honor, I'm going to be requesting a $10,000 bond on one, no victim contact, and or release condition that Mr. Colesser not be in possession of any firearms or weapons during the pendency of the case.
Does he have any priors?
No, Judge.
Okay, Mr. Romero, can you give me a background on Mr. Colesser?
Judge, in speaking Mr. Kostler, he's 38 years old. He's been residing in South Florida for 27 years. He's currently self-employed. He kind of works with Bright Insurance. He makes approximately $500 a week. He lives in Deerfield.
What does he do for the...
A producer, Your Honor.
A producer for an insurance company.
Sales.
In sales.
Oh, okay. All right.
He lives in Deerfield. He's married. He's been married for 14 years. They share 2 children in common, ages 13 and 8. Judge, he takes care of the financial matters, the rent, the utilities, the groceries. He takes care of his 2 children. Right out of high school, he joined the Marines. He was recalled by the government to serve back in the Marines from 2003 to 2004 in Iraqi freedom. Judge, considering his strong ties to the community, he advised me that this is his first contact with the system. He was with the military police, with the Marines when he graduated from high school. Judge, what we'd be requesting is a $1,500 bond on count 1 and and ROR count 2.
What I'm going to do is set a $5,000 bond on count 1, ROR on count 2. If he makes the bond, I'm going to place him with level 2 pretrial release with a monitor. He is to have no contact in any form or manner with the alleged victim, and he is not to possess any firearms until further order of the court. Okay, thank you, everybody.
That's fine. The only thing I just want to make sure, and I don't think it'll hinder him, with level 2, he's the one that actually drives his children to and from school. That's not going to hinder him from being able to do all that, correct?
I will permit him to drive the children to and from school, and also all the other things that are contained in that paragraph regarding pretrial release. He can work, he can go to school, anything like that, okay?
Okay, thank you, Judge.
And as long as he gets permission from pretrial release, he can request them to do things. In other words, if he contacts pretrial and say, "I want to do this, can I do it?" Pretrial release can give him permission.
Okay, thank you, Judge.
Thank you, Your Honor.
Seabrook Shateen. Oh, I'm sorry, it's Corey Shateen Seabrook. Mr. Seabrook, good morning, sir. You are charged with carrying a concealed firearm, resisting or obstructing without violence, possession of cannabis, less than 20 grams, and tampering with or fabricating physical evidence. Your total bond right now is $2,200. I do find probable cause, having read the probable cause affidavit. Can you make that bond of $2,200?
No.
What kind of bond could you make, sir?
500,000.
Judge, he did advise me he was working at Burger King. Unfortunately, he just got laid off from Burger King. Right now...
What about his family?
I haven't talked to nobody. I'm pretty sure they could do something, though.
That's why he believes if the bond was just $1,000, they can come up with the 10% with the bondsman.
State anything that you want to, that I need to know?
No. Well, okay. I don't know if he has a history or not. I don't know if pretrial has any information.
Okay, just give me 1 second.
It's your first arrest, sir? Okay. They'll verify it right now.
Okay, what I'm going to do is ROR him on the resisting officer without violence and the possession of cannabis, and I'm going to set a $500 bond on count 1 and a $500 bond on count 4.
So what all that mean?
Thank you, Judge.
Thank you.
10%.
These are 2 sick cases. 2 of them. Only 2. The ones are not.
Vernon Ashley?
Vernon Ashley, is that a medical reset? Or
Yeah. I told you that, man.
No, not me. Mr. Ashley is a medical reset, Judge.
Okay. And it looks like the last case is Darius Davis.
Medical reset, Judge, as well.
All right. Anything else for this morning, everybody?
Nothing else, Judge. I'll see you this afternoon.
Okay, we're in recess. Thank you, everybody, for your assistance.